I'm not hearing anybody. What's going on?
I'm putting you on YouTube, Your Honor. You should be on it now.
Now we're cooking. Okay. Good morning, ladies and gentlemen. Welcome to Bexar County Court of Law number 6 in the Bexar County Veterans Treatment Court. Today is Wednesday, November 10th, 2021, and we have a motion to revoke probation docket and I believe 3 pleas set this morning. What I've got on my docket is State of Texas versus Monica Moreno, cause 661-269, represented by Ms. Alma Benavides. Cause number 658446, State of Texas versus Jacob Lopez, represented by Mr. Roland Ramos. Cause number 643213, State of Texas versus Philip Perez, represented by Ms. Sunny Middleton. Cause number 650463, State of Texas versus Desiree Howell, represented by Mr. Paul Acevedo. Cause number 633737, State of Texas versus Don Lopez, represented by Mr. Trey Porter. We have 2 Bexar County Veterans Treatment Court Track 1 pretrial diversion plea and probation agreements. Cause number 659814, State of Texas versus Daniel Jolly, represented by Mr. Trey Porter. Cause number 632729, State of Texas versus Noe Leyva, represented by Mr. John Gomez. And 1 regular plea, cause number 644961, State of Texas versus Emmett Hernandez, represented by Mr. Larry Meadows. At this time, let's take up the 2 Bexar County Veterans Treatment Court Track 1 pleas on Mr. Jolly and Mr. Leyva. Mr. Porter, are you ready to proceed?
I'm ready to proceed, and Mr. Jolly is here with me in the office.
Thank you. And Mr. Gomez, are you ready to proceed?
I'm ready, Your Honor.
And let's see. Representing the state in all matters will be Ms. Megan Galloway, Mr. Eddie Villarreal, and representing the Bexar County CSC would be Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. You swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
Thank you. Okay, this is cause number 632729, State of Texas versus Noe Isaac Leyva, represented by Mr. John Gomez, and cause 659814, State of Texas versus Daniel Jolly, represented by Mr. Trey Porter. Initially, we need to identify signatures on 2 documents. Mr. Jolly, in cause 659814, is this your signature on the document entitled Defendant's Consent to Plea by Video Conference, sir?
Yes, sir.
Thank you. And Mr. Porter, as attorney for Mr. Jolly, is this also your signature on this document?
Yes, sir, it is.
Thank you. Mr. Leyva, on cause 632729, on the defendant's consent to plea by video conference, is this your signature on this document?
You're muted, Mr. Leyva.
Okay, thank you. And Mr. Gomez, is also your signature as attorney for Mr. Leyva?
Yes, Your Honor.
The next document I'm looking at is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions, that purports to have your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Jolly, in cause 659814, is this your signature on this document also, sir?
Yes, sir.
And Mr. Leyva, in cause 632729, is this your signature on this document, sir?
Yes, sir.
Thank you. By signing this document, are each of you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any interest in asking questions about what was on this document, those questions were answered to your satisfaction by your attorney, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, Mr. Jolly?
Yes, sir.
And is that correct, Mr. Leyva?
Yes, sir.
As attorney for Mr. Jolly, Mr. Porter, have you had enough time to go over this case with him, and in your opinion, is he mentally competent?
Yes, sir, I have, and yes, sir, he is.
Same question for Mr. Gomez as attorney for Mr. Leyva.
Yes, sir, I have, and yes, he is.
Mr. Jolly, are you a United States citizen, sir?
Yes, sir.
Same question for Mr. Leyva.
Yes, sir.
And Mr. Porter, as attorney for Mr. Jolly, has the state fully complied with discovery for you on this case?
Yes, sir, they have.
Same question for Mr. Gomez as attorney for Mr. Leyva.
Yes, Your
Let's
Honor.
see what we got here. Okay, Mr. Jolly, in cause 659814 to the charge of driving while intoxicated with a blood or breath alcohol content greater than 0.15. How do you plead, sir?
I plead guilty, sir.
Court accepts your plea of guilty. Hold it in abeyance. Places you on 1 year. Bexar County Veterans Treatment Court Track 1 pretrial diversion. assessing a $1,000 all-inclusive VTC fee, 48 hours of community service, probating all that based on your military service, DWI education course, DWI victim impact panel, 6 months Smart Start mobile home interlock at 4 blows a day, outpatient drug treatment with either the Veterans Administration or a designated VTC provider, and no restitution on this one. Nope, no restitution. All good. Requiring your successful completion of the Veterans Treatment Court issue judge's bond. Defendant to be supervised by CSTD and VTC staff. And at this time, Mr. Jolly, I'm looking at a document entitled Track 1 Pretrial Intervention, which is a contract by and between you and your attorney and the Bexar County Criminal District Attorney's Office. Said contract setting out all the requirements and prerequisites of your successful completion of the Veterans Treatment Court. Is this your signature on this document also, sir?
Yes, sir, it is.
And Mr. Porter, as attorney for Mr. Jolly, is this your signature on this document?
Yes, sir.
And Ms. Galloway, as the Assistant Criminal District Attorney handling this case, is this your signature on this document?
Yes, it is, Your Honor.
Okay. And that's what I got. State, what did I miss?
You got it all, Judge.
Mr. Porter, what did I miss?
Nothing else from defense, Judge.
All right. Hey, Mr. Jolly, what'd you do in the military, sir?
I'm a computer analyst, sir,
For which service?
for the Army, sir. Signal.
You're on our team. Thanks for the service. Anything from the state or the defense on Mr. Jolly?
Nothing
Nothing
further
from
from
the state.
defense, Judge. May we be excused?
Yep, hang on. My understanding, and Pat, correct me if I'm wrong, is Ron Mora is going to contact Mr. Jolly and Mr. Leyva after these pleas are over and coordinate getting them squared away with regard to what they need to do.
Yes, sir.
Ron
I'll
is
give him a
on.
call.
Okay, Ron's going to call. All
Yes,
right. Mr. Porter, you've got another case coming up. I'm going to take that one first when we get to it so that I can get you out of here. And otherwise, Mr. Jolly, you're excused. And let's talk about Mr. Leyva.
Thank you, Judge.
You bet. And thanks for your service, Mr. Jolly. Mr. Leyva, on cause 632729 to the charge of driving while intoxicated with a blood or breath alcohol content 0.15 or higher. How do you plead, sir?
Guilty, sir.
Court accepts your plea of guilty, hold it in abeyance, places you on 1 year Bexar County Veterans Treatment Court, Track 1 pretrial diversion, assessing a $1,000 all-inclusive Veterans Treatment Court fee, 48 hours of community service, probating all that based on your military service. DWI education, DWI victim impact panel, 6 months Smart Start mobile home interlock at 4 blows a day. Outpatient drug treatment with either the Veterans Administration or a designated VTC provider. No restitution due on this case. Requiring your successful completion of the Veterans Treatment Court issued judge's bond. Defendant to be supervised by CSTD and VTC staff. I'm now looking at a document entitled Track 1 Pretrial Intervention, which is a contract by and between you and your attorney and the Bexar County Criminal District Attorney's Office. Said contract setting out all the terms and prerequisites of your successful completion of the Veterans Treatment Court. In fact, Mr. Leyva, is this your signature on this document also, sir?
Yes, sir.
And Mr. Gomez, as attorney for Mr. Leyva, is this your signature on this document?
It is, Your Honor.
And Ms. Galloway, as the Assistant Criminal District Attorney handling this case, is this also your signature on this document?
It is, Your Honor.
Okay, state, what did I miss?
Nothing, Judge. You got it all.
Mr. Gomez, what did I miss?
Nothing from the defense, Your Honor.
All good. What'd you do in the military, Mr. Leyva?
I was a 91 Mike, sir, which is dietitian/cook.
You know, some of us in the Veterans Treatment Court could use your services. We'll talk about that at a later date. Thanks for your service, sir.
Thank you, sir.
I noticed a glitch. I'm showing Mr. Leyva's last name spelled Lima, Echo, Yankee, Victor, Alpha. Is that correct, Mr. Leyva?
No, sir. If I heard you correctly, it should be L-E-Y, V as in Victor A.
Well, that's what I said. Lima, Echo, Yankee, Victor, Alpha. So it's Leyva with an E. I see some of this paperwork with Leyva with an A. So Pat and or Ron, that needs to be corrected administratively. Primarily, I'm seeing it on his contract of pretrial intervention. And it actually is spelled in the body correctly. It's just at the top. All right, we'll take care of that. Anything further from the state or the defense on Mr. Leyva?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, Mr. Leyva, thank you for your service. Thank you, Mr. Gomez. Y'all are cut loose.
Thank you, Your Honor. Noe, Ron will give you a call. If you have any questions after that, give me a call, okay?
Okay. Thank you, sir.
You're welcome.
And let's see. Mr. Porter, are you ready to proceed on Ms. Lopez case?
Yes, sir. Miss Lopez is here with me, Judge.
All right, all good. This is cause number 633-737, State of Texas versus Don Lopez, represented by Mr. Trey Porter. Ms. Lopez, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have your signature on it. In fact, ma'am, is this your signature on this document?
Yes, it is.
Thank you. And Mr. Porter, as attorney for Ms. Lopez, is this also your signature on this document?
Yes, sir.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document also, Ms. Lopez?
Yes.
And as attorney for Ms. Lopez, Mr. Porter, is this also your signature on this document?
Yes, sir, it is.
Okay, Mr. Porter, my understanding is this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, sir.
Okay, Ms. Lopez, in cause 633-737 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, ma'am?
Judge, we plead true to both with an explanation on number 2.
Let me back up because I had a discussion with Ms. Gross at CSCD about this, and the state maybe need to be involved. There are 2 allegations on this. Allegation violated condition number 2 talks about consuming alcohol on or about September 9th, 2021. Then there's a violated condition 19, and it talks about having some sort of technical problem with the mouthpiece on the ignition interlock device. And Ms. Gross, am I correct in my recollection that this is not the defendant's fault? That's the position of the probation department?
Yes, Your Honor, she has provided a letter of documentation showing that it was a faulty mechanism and it has since been replaced. And I believe there's been no new issues.
Okay, state, if you agree with that statement, I'm going to request that you waive condition 19. We don't have to talk about it.
Yes, Your Honor.
Okay.
Sorry.
Court grants the state's motion to waive condition 19, no objection from the defense. So all we're talking about at this time is consuming alcoholic beverages on September 9th, 2021, which I believe came as a result of a urinalysis test. Does that sound right, Susan?
Yes, Your Honor.
All right. Ms. Gross, at this time, if you would please advise the court and the parties of the status of Ms. Lopez's probation.
Yes, Your Honor. Ms. Lopez has been reporting as directed. We last saw her on October 11th of 2021. Her case is paid in full. She's completed all 48 hours of community service, as well as DWI education, victim impact panel, and the CATSNP program. She is currently on the ignition interlock device and had 16 disconnects from the device. She did provide documentation showing that it was a faulty device. It has since been switched out and there should be no issues moving forward. She's had 4 negative drug tests and she had 1 positive drug test for alcohol, to which she also admitted consumption. This is her first violation report, first MTR. She has no criminal history, and her officer is recommending scram for the duration of probation.
And let me back up before I turn you loose, Mr. Porter. State, have you received what I want to mark as Defense Exhibit 1 for identification, which is a wonderfully prepared packet on this case that has a beautiful picture of Ms. Lopez on the front. It's not exactly accurate because she's not holding a beer, Mr. Porter, but other than that, this is the most wonderful packet I've ever seen in 40 years of lawyering from a defense counsel. So well done.
I appreciate that. Ms. Galloway, you should have received it via email. If you have not, we can certainly email it to you. It just contains what has already been provided.
Ms. Galloway, is the state in possession of this document?
Mr. Porter, would that have been sent to me by Mr. Strickland?
It may have come from Mr. Strickland. However, Ms. Galloway, I can email it to you right now if you'd like, if you don't have it handy. I do have.
Yes, if you could please do that.
I can orally describe what's in this document for the state, or state, we can take a break and you can wait till you get it, whatever you'd rather do. But it's very professionally done, and it basically sets out exactly what is going on in this case. Would you agree with that, Mr. Porter?
Yes, sir. And there are no items in that the state does not have direct knowledge of, Judge.
I agree. So, Ms. Galloway, do you want to wait and get a copy of this, or do you want me just to describe it for the record?
Judge, you could just describe it for the record. That's fine.
Okay. What I am marking as Defense Exhibit 1 for identification is a packet describing Ms. Lopez and her job position and all aspects of this case. The only allegation against Ms. Lopez in the pending motion to enter adjudication of guilt and revoke community supervision is a positive for alcohol rendered as a result of a urinalysis test on or about September 9th, 2021. The packet has a lovely picture of Ms. Lopez on the front. Then it has a defense court summary, a drug test result from Monday, 11/8/21, a Draeger repair receipt and email, which were to cover the 19 issues with the mouthpiece on the Draeger ignition interlock. Her job duties of her present job, where is, let me get to that and I'll read that to you. Ms. Lopez is presently employed as lead therapist, site lead for Bering Straits contractor Lackland Air Force Base, where they plan and operate safety procedures for pilots, correct any issues with operational human weapon systems, plan and execute healthcare for F-16 jet pilots, educate proper body mechanics for treatment and care, maintain complete knowledge with all State Department and national procedures, policies, and standards, and oversees all human performance variants of program for growth and success. And what I get from this, and please correct me, Mr. Porter, is Ms. Lopez is a Department of Defense contractor employed at Lackland Air Force Base and basically is dealing with the welfare of American fighter pilots. Is that kind of where we're at?
Yes, sir, that is correct.
This document also shows that she is paid in full. She's completed DWI education, the Victim Impact Panel, the Community Alliance for Traffic Safety New Intervention Program, and 48 hours of community service. All have been verified by Ms. Gross at CSCD. And we'll talk about this. So she's been on an ignition interlock and not my standard order, Smart Start Mobile, which we'll talk about in a moment. Looks like there's a copy of the test where she was positive for alcohol. There is a narrative apparently written by Ms. Lopez at the very back, which states, I manage several aspects of F-16 jet pilots' health and wellness at my unit, from sports therapy to medical nutrition therapy and whole wellness care. As I'm under medical board, I follow strict procedures and requirements for patient safety and operational security. I oversee instructor pilots and IPUG B course students, SOC students, averaging 75 pilots and student pilots daily, revolving their program set forth with our command and myself for their daily activities involving the program. As operating site lead, I manage budget, funding, financially planning, and oversee all growth aspects of our program. Attend all meeting requirements, review all expansive communication and base command and proper channels, attend weekly meetings, and discuss growth and patient review with COR and PCOR. Oversee and manage fellow contractors employed on our project. Constraints of my job is I'm in a secured building with no outside people or electronics allowed. Our building is a secure facility with no outside electronic devices allowed or must be cleared through appropriate channels through the communications department. My job is an all-day affair. I'm on call 24/7. Limitations with my job do not allow me to leave on scheduled timeframes, as some meetings within our vault or with command can be extended when in debrief. If I were to leave, it would come with severe consequences, as well as if I'm a patient and an issue with pilot were to advise proper procedures to Reed Hospital. If necessary, would need to be set in place, changing the outcome schedule of my day. Training in fellow bases not limited to Luke Air Force Base, Laughlin Air Force Base, and Vance Air Force Base. These trainings can be monthly or scheduled for TDY. Then there's a copy apparently of her employment contract with Global Solutions, which sets out the requirements of her job position as previously stated. Okay, would you say that's an accurate evaluation of this document, Mr. Porter?
Yes, sir, it is. And Judge, just one clarification for
Sure.
purposes of the record. Item number 5 in the packet, and also Ms. Galloway, I have now emailed that to you, so you should have it for your record as well, is a job that is awaiting Ms. Lopez. It is similar to the job she currently has, but it is essentially, Judge, her next job down the line. We wanted to provide proof of that to the court, as the ramifications of today could certainly impact Ms. Lopez's ability to accept that position and move forward with that when her contract here at Lackland ends.
Okay, would her accepting this new job, if that were possible, make her move her residence from San Antonio to some other location?
It would, Judge, but not until the term of her probation is over. This job would not come into effect until after her probation with your court terminates in May of 2022. She's on probation with you through May of next year, Judge.
So defense, I'm guessing that you are requesting that for purposes of this hearing only, the defense is asking that defense exhibit number 1 for identification be admitted into evidence as defense exhibit 1. Is that correct?
Yes, sir, that is correct.
State, any objection?
Your Honor, I have received the packet and I have no objection.
Thank you. It shall be admitted. Okay. Hey, Ms. Lopez and Mr. Porter, do I have your permission to talk to Ms. Lopez about her security requirements and her security clearance and those sorts of things?
Yes, sir, you do, and she is right here, Judge.
Okay. Hey, Ms. Lopez, what do you actually have a security clearance at this time?
Currently, I'm on hold until we reconvene at the end of today.
And bear with me, I'm having a hard time understanding. Was that a yes or a no?
How would I consider that?
She does, Judge, but it is currently on hold because of the active warrant and the active MTR.
And what is the level of her current clearance that's on hold? There's top secret special background investigation, top secret compartmentalized, all those things.
It's just top secret, Your Honor.
Or just straight top secret?
Yes.
Okay. Does your current organization, are they aware that you have these criminal charges pending and you're on probation?
Yes, my command on base and my employer for my contracting position with Bering Straits is aware.
But as long as you're in good shape with the court, they're not objecting or going to try to cancel your job based on this case. Is that correct?
That is correct.
So really what we're talking about is the fact that under your strict circumstances of employment, you can't take electronic devices in the building you work in because it's just that's a standard with any kind of secure military locality that I'm aware of. So that's what we're dealing with. And therefore, I believe defense, you're representing that a scram bracelet, which would be semi-permanently affixed to the defendant's leg, would not allow her to work in a secure building. Is that what your allegation is?
Yes, sir. That it is my understanding that Ms. Lopez would not be allowed to enter that secure facility, and her inability to do that, Judge, would result in her immediate termination.
All right, let's right now, currently we are on an ignition interlock, and I don't have a finite recollection of this, but my guess is that Mr. Porter sweet talked me into allowing that based on Ms. Lopez's employment requirements. And she's probably the only one or two that we have out of the 1,000 people we have on probation in county court at law number 6 that's on an ignition interlock and not a Smart Start mobile portable device. Would you agree with that analysis, Mr. Porter?
Yes, sir, I would. I did not, for the record, Judge, I did not represent Ms. Lopez on her case with you initially. That was, I believe, Mr. Roundtree.
Okay.
I believe that he brought this up. Her employment was the same at the time, Judge, so the facts that we've reviewed today were applicable then and they're applicable now.
All right, Ms. Lopez, let me bounce this off of you. You currently have an ignition interlock, and as we're all aware, and as the results of this, your analysis test show, an ignition interlock only works when you blow in the device that's located permanently or semi-permanently in the automobile that you're going to drive and test you right then and there when you get ready to drive the vehicle. It does not test you any other time of the day. Would you agree with that, Mr. Porter?
Yes, sir. We agree with that, Judge.
All right. Ms. Lopez, my other option other than a scram device is called a Smart Start mobile device. And it's a device about the size of a cell phone. And I'm sure is equally not eligible to come into your building, just like a scram device would not be. However, normally you would blow 4 blows a day. If you violate, we crank it up to 6 blows a day, but you have a 2-hour window to blow in the machine for each blow. would that not allow you an opportunity to leave this device in your vehicle? And within that 2-hour window, go out and blow in the machine and then go back into your building?
Judge, I can let Ms. Lopez expand on that, but it is my understanding that Ms. Lopez essentially is on call 24/7. She doesn't have a regular schedule. So when she is called to work into that secure facility, she has no control over the timetable and is thus unable to commit to windows. And this is something, Judge, that we have provided information to the court on. We could certainly provide additional information. One thing I would suggest as an alternative, Judge, because I understand what you're saying about you don't have any, checking on her when she's not blowing into the device. Ms. Lopez is able to take drug testing as frequently as this court would like her to. So if you would like her to test 2, 3, 4 times a week, which would cover the full 7 days of the week, Judge, she can do that because she could essentially do that at any time.
All right. Once again, Mr. Porter, do I have your permission to talk to Ms. Lopez about this situation? Because she's the one that's doing it, not you.
Yes, sir. You do. Here she is.
Ms. Lopez, you heard my question that your attorney answered for you. I want your answer. If you have a 2-hour window and you're blowing 4 or 6 times a day, that's going to be either 4 hours or 6 hours every 4 or 6 hours. Then you would have a 2-hour window to blow in the machine. Would that not normally during the daytime hours give you enough time to go to your car and blow in this machine and leave it in your car so you don't violate security regulations at your job position?
Your Honor, the accuracy of giving time, I cannot allocate. That is my only issue.
All right, I'm not communicating clearly enough. I've got 2 options. A, we can attempt to rehabilitate you and have you not do any more colorful drinking on us, or B, we can go to jail and move along, and you're not going to be able to go to your job while you're in jail. So, Mr. Porter, if you want to go chat with Ms. Lopez in a chat room briefly, here's my options. Either she agrees to a Smart Start mobile device. I'm going to start it at 6 blows a day. So that's every 4 hours. So that means she'd have to blow into it 2 or 3 times a day while she's at work, if I were guessing. If she's at home, that shouldn't be a problem because there's no security restriction. But I don't understand, since I had a top secret special background investigation with Special Forces Command, if I had a Smart Start mobile device, I didn't have a problem within my 2-hour window going out and blowing in the device in my car and coming back in the building and being cleared again. So I don't understand why Ms. Lopez would either.
Judge, my understanding is that no matter what the windows are, a couple of those windows are going to occur inevitably while she's at work. If she has a 2-hour window, for example, between 2 and 4 p.m., and her command has called a meeting that day that necessitates her to be there between 2 and 4 p.m., she can't go out to her car. And so while I agree that this may be something that may be practical for her to do with some regular frequency, we're just trying to be honest to the court ahead of time and say, based off of her everyday experience at work, there are going to be times where she's stuck. And we don't want to have to come back to you or to contact the court every time a meeting has been called that she can't leave because she's not in charge of it or the timetable. That's our dilemma here, Judge.
My suggestion would be, if that were to occur,
okay,
then she would need to, as quickly as possible, go out to her vehicle and blow in the machine, and then call her probation officer and explain what happened. And ultimately, that's going to end up on my desk, and I have your cell phone number.
You do.
If that becomes a problem I'm concerned with, you and I will talk about it. But at this point in time, I understand Ms. Lopez has a sweetheart job, and she's doing good things for the country. And if I can stop her from drinking, it'd be even better. But I've already cut her as much slack as I can possibly cut through Mr. Roundtree, apparently, by not putting her on a Smart Start originally. And that's not happening again. So her 2 options are: A, try my idea with a Smart Start mobile. I'll leave her on deferred adjudication, which is another gift from God, and put her back to work, and off she goes. She's done everything else, I think.
She has, Judge.
Susan, go ahead.
If I may, in reviewing her case notes in preparation for today's hearing, Ms. Lopez did admit to the alcohol consumption as a result of, I guess, some incident in her life. I don't know. And there have been no other issues. She's been very proactive in completing everything in a timely manner and being successful on this. And I personally, I believe that a Smart Start mobile device would not work in this case due to her job status. I understand the court's concern. She has been staffed in regards to this alcohol consumption. I believe that she has realized her mistakes and what another drinking incident could result in, AKA a conviction, job loss, et cetera, et cetera. And if we put her on a Smart Start mobile device, being that she's on call 24 hours a day, number one, it would be difficult to set up a testing schedule. And number two, I think it would be difficult on her part to adhere to that schedule. And it would create more headaches on not only her part, but probation departments as well as the court's side. So, I mean, obviously we're going to do whatever the honorable court wants to do, but that's probation's 2 cents on the matter.
So is probation recommending that the court not impose any alcohol monitor on her? Is that what you're saying?
No, not at all. Her officer recommended scram, which we know is not a valid recommendation based on her job and job description, etc. Leave her on the device in her car and continue that. But as far as putting her on a Smart Start mobile device with a schedule, I don't think is going to work for her due to her job and her obligations and the fact that she is in a secure environment working with individuals that are fighting to keep our country safe.
And Judge, if I may, we will do everything we can to supplement the ignition interlock device monitoring with drug testing as often as possible. And Ms. Lopez has been drug tested once a month almost since she's been on, and she's committed to doing that, you know, in an effort to provide the court with as clear of a picture of what's in her body as possible, Judge. We know this is a unique circumstance, Judge. She's done everything else, and we were just truly asking for a second chance, and we understand that it's a big ask from you, Judge.
State recommendation.
Your Honor, in this case, the state is going to recommend that the defendant be continued on deferred adjudication and that her conditions be altered and amended to be placed on weekly UAs. However, we would request that she, all of her other conditions remain the same and that she be kept on the same ignition interlock device, Your Honor.
And Ms. Gross, when you indicated that Ms. Lopez came clean about her alcohol use, was that before the results of her urinalysis tests were known or after, and a probation officer contacted her and said, "You're hot for alcohol, what happened?"
If you give me just a second, Judge, I can look up the exact date as to when that conversation took place, or Ms. Lopez may be able to shed some light on that for you.
Let me ask my client, Judge, 1 second.
Sure. I already know the answer, by the way.
Judge, Ms. Lopez does not have a recollection of preemptively discussing anything with her probation officer. However, we don't have anything that says that this was challenged. At least I have not been provided anything with that from probation, and I don't have that from Ms. Lopez either.
Okay. Ms. Lopez, in cause 63737, On the motion to enter adjudication of guilt and revoke community supervision, the court accepts your plea of true with an explanation. The state having already waived condition 19, so you're only pleading true with an explanation to condition 2. I deny the state's motion to revoke your deferred adjudication probation or to continue it on deferred adjudication probation with all prior requirements with no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary?
No, sir.
Good answer, ma'am. Altering amending conditions, adding the Smart Start mobile device at 4 blows a day, not 6 blows a day, which would be normal. And as soon as the Smart Start mobile device is active, you may turn in your ignition interlock. This is going to be a test time frame. Mr. Porter, you've got all my contact information. If there are problems, get back to me. Ms. Lopez, if there is a time frame that you cannot leave your building, go blow in the machine in your car and come back, you are to blow in the machine at the earliest possible time after you've been in a meeting or whatever you're doing, and then call your probation officer and explain what happened. And if any of these get out of hand or I think they're unreasonable, we'll talk again, and Mr. Porter, you'll be my first call. She's already got, what, 4 months time frame with us at this time?
I believe, Judge, we're coming up on the 6-month mark with the device.
She started late in May, so June, July, August, September, October is 5 months. Does that sound right?
Yes, sir, that's
Yes,
correct.
Judge.
We're in our 6th month.
She's actually eligible to come off here in about 3 weeks.
All right, let's see how well she does on my Smart Start mobile program tailored specifically for Ms. Lopez. And obviously, anytime after 6 months, I have the authority to take it off. Mr. Porter, you got my contact information. Let's see how this works and we'll go from there. Anything further from the state or the defense on Ms. Lopez?
Nothing further from the state.
Judge, 10 days to obtain the device?
Yeah, if she needs even more than that, that's okay. She's already got an ignition airlock still going.
Judge, only thing from defense, we asked for the warrant to be recalled in this matter.
I'm going to recall all prior PTS bond conditions and warrants. So that will probably not be on the computer till tomorrow morning, Trey, but it'll be on the computer as soon as possible.
Yes, sir. Understood.
Okay. And Ms. Lopez, thank you for your service, ma'am.
Your Honor, tomorrow is a holiday.
Give her 15 days to get the machine on with holidays and stuff. Maybe that should be enough time, don't you think?
Understood.
Okay.
Yes, sir.
Good luck,
Ms. Lopez, you'll be receiving some documents from me later today via your email. You'll need to electronically sign them and send them back. Trey, do you have a list of the Smart Start mobile locations?
I do, but Ms. Gross, if you could, will you just send an updated one so we'll have whatever is newest from you guys?
Okay.
I
And then she can go over there and get on the list because they probably won't be able to give her one today.
Okay. Judge,
Okay.
thank you, sir, for your consideration.
Mr. Porter, I don't want you to go back to the office and commit suicide because you didn't get what you want. A, I didn't revoke her. B, she's not on scram. C, I didn't order weekly UAs. And D, I didn't crank her up to 6 blows a day on the Smart Start. So that would be a defense win under the circumstances, in my opinion. If there are any problems, call me straight ahead, specifically bypass everybody else.
I will. Yes, sir. Thank you, Judge. May we be excused.
Yes, ma'am. Good luck, Ms. Lopez.
Thank you.
And are we ready on Ms. Moreno and Ms. Benavides?
Yes, Your Honor.
Yes, Your Honor.
This is cause 661-269, State of Texas versus Monica Moreno, represented by Ms. Alma Benavides. Ms. Moreno and Ms. Benavides, the first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both your signatures on it. In fact, Ms. Moreno, is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. And Ms. Benavides, as attorney for Ms. Moreno, is this also your signature on this document?
Yes, Your Honor, it is.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Ms. Moreno?
Yes, Your Honor, it is.
And Ms. Benavides, as attorney for Ms. Moreno, is this also your signature on this document?
Yes, Your Honor.
My understanding, Ms. Benavides, is this is going to be an uncontested motion to revoke community supervision. Is that correct?
Yes, it is, Your Honor.
Ms. Moreno, in cause 661269 on the motion to revoke community supervision, how do you plead, ma'am?
Guilty,
Your-
Your Honor. Oh,
Your
sorry.
Honor, there are 3 violations that she's pleading not true to, and the rest she is. So if it, with your permission, I'd like to just state on the record that she's pleading not true to violation of condition number 2, number 17, and number 18, and true to the remaining violations with an explanation.
That was true to number 2 and number 18, did you say?
Not true,
Oh, I'm sorry. Not true to 2, correct?
correct,
And not true to number 18, is that correct?
correct, and number 17.
And number 17, I've got it. Let me read these real quick. Got that. Got that. You got that. And just for the record, Ms. Benavides, when Ms. Moreno, well, anyway, she's pleading true with an explanation to the rest of them. Is that correct?
That's right, Judge.
All right. Ms. Benavides, excuse me. Ms. Gross, would you please advise the court and the parties of the status of Ms. Moreno's probation?
Yes, Your Honor. Ms. Moreno has been reporting as directed. We last saw her on October 15th of 2021. She has paid $229 towards her fees. She has a balance of $1,015, and she is delinquent $146. We have no record of any of her 36 hours of community service having been completed. She has completed the victim impact panel, and we have no proof of completion of DWI education or CAPSNP programs. She has had 1 positive for alcohol and 1 negative drug test. She's currently on Smart Start mobile device, testing at 4 times per day, and has had 3 skip tests and no high bracs. However, we do have multiple issues on multiple occasions where some other person is blowing into the device providing the tests. In addition to that, because Smart Start is a GPS enabled device, it has also recorded that she has left the county without permission of the court on 7 occasions. This is her first violation report, first MTR. She has 1 prior DWI of 0.15 or higher. Her officer is recommending that her Smart Start mobile be increased to 6 blows per day and that she provide weekly drug testing.
Ms. Benavides, what are you requesting?
Your Honor, we're asking the court to allow Ms. Moreno to continue her probation. I've addressed these issues with her, and she understands the severity of allowing or requesting that another individual blow for her. The explanation that she has given me is that she works 2 jobs, server at 2 local restaurants, Alamo Draft House and another restaurant called Dogfather Restaurant. She says she works 50 to 60 hours per week, and she has left the device. She's not driving. She's left the device in the vehicle of a friend who provides transportation for her. On a few occasions, I can't tell you exactly how many occasions, but she says that it's been several occasions, and she was not able to blow into it because she didn't physically have it with her. And so she says she panicked and asked a friend to blow for her. I've advised her that she can't do that. That needs to stop. She understands that. She wants to apologize to the court for doing that. She claims that will not happen again. She did leave Bear County. She claims that she went to a family function and she understands that she cannot leave Bear County without a travel permit. She has agreed not to do that again. She claims that she did complete the intervention class, and that was on November the 2nd. The VIP class, she claims that she completed on September the 15th. And if the court allows her to continue with her probation, if she's released from custody this week or today, she will sign up this week for CATSNP. She lives alone, but she says that she will be getting a roommate who will be contributing financially. So for rent, so she will have the funds with which to take and sign up for the CATSNP class. She claims that she just got health insurance through one of her employers, and that will also afford her the ability to also participate in some additional counseling that she feels that she needs, some personal counseling.
State recommendation.
Your Honor, the state recommends that this defendant be continued, placed on scram, placed on weekly UAs, and ordered to substantially comply with the terms of probation within 10 days of this hearing.
Susan, what was the original fine amount on Miss Moreno's case, if you know?
Yes, Your Honor, it was $500.
Ms. Moreno, in cause 661-269, the court accepts your plea of true to all conditions except number 2, number 17, and number 18, not true. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bear County Jail, assess a $500 fine plus court costs, credit for time served, time and money to run concurrent, recalling all pretrial services, bond conditions. Anything further from the state or the defense on this, Moreno?
Wait, I'm sorry. Are you saying 6 months I'm being held? Is that what you're?
I could have given you a year, but you have been reporting, so I'm giving you credit for that. So you're getting 6 months in jail. My last understanding, the sheriff's giving a 3-for-1 quotient. I don't know what it is today. That's up to the sheriff.
Your Honor,
Do you want to go into a chat room and explain to Ms. Moreno what's going on?
Yes, Your Honor.
Pat, why don't you send him to a chat room, please?
Yes, of course. Hold on, Your Honor. Let me find. I'm gonna go into 2. I'll send Ms. Moreno to room 2.
Thank
Okay. Are we ready on Mr. Lopez?
Your Honor, you have the paperwork. You need to print it, I believe.
Oh, let me look. Let's take a 2-minute break while I do all this stuff.
Miss Pat, this is Sunny.
Huh?
Do you have any idea where I am? I'm just waiting to take a plea also up here in Guadalupe, so I'm just.
You're the next one right after Mr. Lopez.
All right, thank you, ma'am.
You're welcome.
Okay, back on the record. This is Bear County Court Law number 6 in the Bear County Veterans Treatment Court, and we're having our motion to revoke docket at this time. Mr. Ramos, are you ready to proceed on Mr. Lopez's case?
Yes, Your Honor, we are.
This is cause number 658-446, State of Texas versus Jacob R. Lopez. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I'm looking at, Mr. Lopez and Mr. Ramos, is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, that purports to have both your signatures on it. In fact, Mr. Lopez, is this your signature on this document, sir? And you turn your microphone on, sir.
Yes, sir. Yes, sir.
Excellent. And Mr. Ramos, as attorney for Mr. Lopez, is this your signature on this document?
It is, Your Honor.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal, unquote. Is this your signature on this document also, Mr. Lopez?
Yes, Your Honor, it is.
And Mr. Ramos, as attorney for Mr. Lopez, is this also your signature on this document?
It is, Your Honor.
Okay, once again, this is cause number 658-446 on the motion to enter adjudication of guilt and revoke community supervision. My understanding, Mr. Ramos, says this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
That is correct, Your Honor.
All right. Mr. Lopez, in cause 658-446 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
Guilty, Your Honor. It's going to be true, Your Honor, on behalf.
Court accepts the plea of true with an explanation. Would that be adequate?
It is, Your Honor.
And Ms. Gross, at this time, would you please advise the court and the parties of the status of Mr. Lopez's probation?
Yes, Your Honor. Mr. Lopez has been reporting as directed. We last saw him on October 21st, 2021. He has paid $121 towards his fees. He has a balance of $1,181, and he is delinquent $149. We have no record of any of his 48 hours community service having been completed. He has completed the victim impact panel. We have no record of completion of DWI education or the CAT-SNP program. He has 2 positives for substance abuse, one being a positive UA for marijuana and one for alcohol. He's currently testing 4 times per day. He's had 5 skipped tests. This is his first violation report, first MTR. He has a prior assault bodily injury family and possession of a controlled substance, penalty group 2, less than 1 gram. And his officer is recommending that Smart Start be increased to 6 times per day and that he be placed on weekly drug testing.
Mr. Ramos, what are you requesting?
Judge, we're asking the court respectfully. He spent for the last 5 days in jail awaiting them putting a GPS tracker on him. The explanation I'll give the court is he was foolish and violated the terms of this court's probation, and there's no excuse for that. I will offer the court that the price paid for this, Judge, he was a commercial truck driver like his father. He had worked 5 years in the oil field. As a result of this case, that is no longer the case. He is suspended. He cannot be a truck driver, and he is installing solar panels for cloud solar energy. He received a diagnosis several months back of a very serious illness that I would rather not share, given that this is streamed, Your Honor, but it's has the potential down the road to be a fatal illness. He's dealing with that and is medicated and doing well. We'd ask the court respectfully to allow him to continue on this probation, to allow him to continue to work. The 5 days in jail was a very enlightening experience, and he has made it very clear that he will never set foot in that jail again, nor violate this court's probation. If this court would allow him to continue on this probation, he is compliant. In fact, he has the interlock device still and would need an order to remove that, given that he's Smart Start compliant. And he has a little boy, a 5-year-old son, Mateo, that he provides for. So he's able to maintain his employment. And I don't believe that this court will see this young man before it again.
State recommendation?
Your Honor, the state agrees with probation's recommendation in this case.
And I'm sorry, you agree with the probation recommendation? Is that what you said?
Yes, Your Honor.
Susan, on Mr. Lopez's original case, what was the fine amount and what was the number of community service hours?
Judge, his original fine was $675. And he was ordered to do 48 hours community service.
$675 plus court costs. That sound right?
Yes.
And judges, the court can see there, he was granted in late September, I think the 23rd. And Mr. Lopez, you have completed DWI education, correct? They just don't have proof of it?
I printed it out. I assumed that they would have it, but yes, I have it. I completed it last week along with the victim impact panel.
Judge, he'll get the next programs and onto community service. Obviously, he's working and traveling for work and doing what he needs to do, but we'll make sure that he expeditiously completes the other conditions that the court has imposed. He's been on a short time, but he will get through it.
Let me back up. You just indicated he's traveling for work. Does that mean outside Bexar County?
Yeah, he has permission to travel, Judge. He wants to be able to travel. The court granted permission to travel with his solar company to install. The court said he can travel and come back, but if he does, he has to give an ETG, and if he travels overnight, he must get permission. We did not represent him on his prior case, but that order is already in place, Judge, and hopefully we won't have to bother the court with that travel permit, but should it come up, we will.
All right. Mr. Lopez, in cause 658-446, the court accepts your plea of true with explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of obstruction of a highway. I'm going to give you a sanction of 10 days, Bexar County Jail, credit for time served, judgment satisfied, so the jail time's over. The new sentence is 6 months in the Bexar County Jail, probated for 1 year, a $675 fine plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, weekly UAs. Once he shows me 4 clean weekly UAs from this point forward, Mr. Ramos, I will take him off weekly, put him back on monthly. You just need to let me know that has happened. He's going to get a Smart Start mobile device for 6 months. Initially, it's going to be at 6 blows a day. If he shows me a 30-day period of time, Mr. Ramos, where he has not made it, any skipped any tests or have any high brax or alcohol, I'll crank him back down to 4. Once again, I will not know he's done that. You got to let me know. He gets credit for any programs done, any monies paid. I'm ordering substantial compliance in all areas within 30 days, meaning anything he has not done at this time, he needs to be registered for and actively involved in within 30 days. And the travel orders remains the same. I think you indicated if he goes somewhere overnight, he needs to get permission. Otherwise, he just comes back and takes a UA. Is that what the old program was?
That's what I saw in the order, Judge. That's what I saw in the court's orders on the document.
And Judge, just to clarify on the travel,
Yeah.
if it's going to be like a single one night overnight, you authorize the probation officer to issue that travel permit, or do you want a supplemental report every time?
Probation can do it.
Thank you.
Anything further from the state of the defense on Mr. Lopez?
Judge, the only thing would be he currently has an ignition interlock that he self-imposed. Can we get an order? And I believe it's already in the orders, but can I submit something to get an order sent over so that Smart Start they can remove that interlock device from his vehicle?
As soon as the Smart Start device is active, he can remove the interlock. All right, he's active on it already. Well done, Mr. Lopez. And Susan, if Mr. Lopez was already on an ignition interlock, that's another one to slip through the cracks. Have all your officers check anybody on a DWI or obstruction probation, confirm they're on Smart Start at 4 blows a day. We're having major problems with that for some reason.
Judge, his attorney just stated that it was a self-imposed putting the device on. It wasn't the court.
Did the court not order Smart Start from the start, Mr. Ramos?
Mr. Lopez, you informed me that it was, you went and put that on, correct?
Yes, that was before my court date. I wasn't aware of that I had to be on the Smart Start mobile, Your Honor.
Okay, well, with the .102 blow that was consumption of alcohol blow, is that on a Smart Start mobile device, I have to assume?
Yes, that's on the Smart Start mobile device, but prior to him pleading on this case originally, he had out on his own accord, he went and got an ignition interlock. So it had nothing to do with the court.
All right, so he's already active on Smart Start. He may turn in the ignition interlock.
Okay, Mr. Perez, I will create an order. If it's okay with the judge, he'll sign it. And I'll send it to your officer. They will forward it to whichever interlock company you have. And then when you get out of jail, you'll be able to go and remove that device, and your officer will also increase your blows. I'm going to be emailing you a document later this afternoon that once you get out of jail, it'll be in your email. You need to electronically sign it. Or no, I take that back. Ms. Benavides is going to be sending you some paperwork, and you need to fill out a new history, just like you did when you applied for probation. It's a brand new application, and you need to send that back. And then the probation department will reach out to you. It'll probably be next week, being that tomorrow is a holiday. So if you haven't heard from probation by Wednesday morning, then reach out to your attorney and he can contact me, and I will see what the status of your case is. Okay.
Yes, ma'am.
All right. Do you have any questions?
When will I be admitted to jail?
You're already done, Mr. Lopez. I'll talk to you right now. I'll give you a call once we log off. I'll explain it. Judge, I checked with Smart Start yesterday. We had a client get released on GPS. I went ahead and had them set up for Smart Start Mobile. Just so you know, it's an 8-day wait right now as of yesterday.
Okay.
An idea of where Smart Start's at on that, just so, and that was as of yesterday. It could be shorter today or longer, but as of yesterday afternoon, it was 8 days for a mobile device.
Okay. All right. Thanks.
Thank you all. May we be excused, sir.
Yes, sir. Thank you.
Thank you all.
Ms. Middleton, are you ready to proceed on Mr. Perez?
Yes, Your Honor.
Okay, this is cause 643-213, State of Texas versus Philip Perez. This is a motion to revoke community supervision. Mr. Perez and Ms. Middleton, I have two documents for you to identify your signatures on. The first one is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Perez, is this your signature on this document, sir?
Yes, Your Honor.
And Ms. Middleton, as attorney for Mr. Perez, is this your signature on this document?
Yes, Your Honor.
Pat, for housekeeping purposes, the copy of this document I have does not have Mr. Perez's name at the top where it says State of Texas versus, mine's just blank. Then it says I, where it should say Philip Perez, hereby waive my right. That's blank.
Okay.
And his printed name is blank.
I'll look at it.
Signatures are on it. So that needs to be corrected at some point. All right. Next document we have is entitled Trial Court Certification of Defendant's Right of Appeal, which should be marked as a revocation of the defendant's community supervision. And the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. And once again, Pat, on this one, that is not marked on my copy. My signature and the date I signed it is not on this document for some reason.
I'll double check, Your Honor, and see what's going on.
And Ms. Middleton's signature on it. So that being said, Mr. Perez, in cause 643-213 on the trial court certification of defendant's right of appeal, is this your signature on this document also, sir?
Yes, Your Honor.
Thank you. And Ms. Middleton, as attorney for Mr. Perez, is this your signature on this document?
Yes, Your Honor.
Thank you. Ms. Middleton, my understanding is this is an uncontested motion to revoke community supervision. Is that correct?
Yes, Your Honor.
Mr. Perez, in cause 643-213 on the motion to revoke community supervision, how do you plead, sir?
Guilty.
No, it's true with an explanation.
True with that.
Court accepts the plea of true with an explanation. Is that accurate, Ms. Middleton?
It is, Your Honor.
All right. Ms. Gross, would you please advise the court and the parties of the status of Mr. Perez's probation?
Yes, Your Honor. Mr. Perez has been reporting as directed. We last saw him on October 12th, 2021. He has paid $356 towards his fees. He has a balance of $890 and he is currently delinquent $138. We have no record of any of his 36 hours community service having been completed. He has completed the drug offender education program. However, we have no proof of enrollment or completion of DWI education, victim impact panel, or the CATSNP program. He is currently testing on Smart Start Mobile at 4 times per day. He has had 1 skip test. He has had 4 negative drug tests. He has had 3 positives for marijuana. He is currently on weekly drug testing, and he has failed to call the UA line on 2 separate occasions. We were here on a motion to revoke back on August 31st. Or I apologize. There was a violation report that was submitted to the court back on August 31st of this year. And you had ordered him to go through a drug offender education class and do the weekly UAs and show substantial compliance within 10 days. We have no proof of registration, so he hasn't complied with that aspect of the other 3 classes. And it does appear that he continues to use marijuana. Therefore, being this is his 2nd violation report, 1st MTR, the officer is recommending that he go to SATA for 120 days, followed by aftercare, and his only prior arrest is for a possession of marijuana 0 to 2 ounces.
Okay, so he technically has not had a prior MTR. He had a prior violation report, and we just amended his conditions of probation. We didn't actually have a formal MTR. Is that correct?
That is correct. No MTR was filed, and the court was gracious enough to give him the opportunity to try and render his faults by merely ordering weekly drug testing and the drug class. He did do the drug offender education class. However, he has not complied with the sanction of the weekly drug testing in that he has failed to call on 2 occasions. And as stated in the MTR, that he has continued to use marijuana.
And the prior violation report did not result in an MTR. Did that allege marijuana positives also?
I believe it did. Let me pull that up. 1 second. Judge, on that prior MTR, it did allege a positive for marijuana on August 18th, 2021. And at that time, you ordered that he go on weekly drug testing and show substantial compliance within 10 days in the drug offender education class.
And what is the last urinalysis test date we have on Mr. Perez as of now?
Judge, his last test was on October the 18th, and it was negative. He had one on October 5th, negative, October 1st, negative, September 23rd, he failed to call. And then prior to that, he had a positive.
Okay, so the last UA we have on him is October 18th.
Yes,
Isn't he supposed to be on weekly UAs?
yes.
So why are there no more UAs after October 18th?
Let me see if there's any more in the actual NORCM.
I don't know when he got picked up, Your Honor, but he's in
He
there
has
right
been
now.
in
That may be
custody.
why.
I'm sorry, what was that, Sonny?
He's in custody right now, so he may have been in custody for a little while. That's why he has no mark.
That could well be part of the issue. Okay. Ms. Middleton, what are you requesting?
Your Honor, we're requesting you continue him on probation His truer than explanation is a lot of the classes and stuff, he's correct. He has not done it because they cost money. Money has been his problem. He was going to the CAT-SNP program. He says he had 4 to go. And according to him, the community service is true, but he was told by the probation, he says his probation officer, that to do the classes first. Like I said, he was low on money. He does construction work, and we have had lots of rain this year. But he's also been able now, the last 2 weekends that he was working, to pick up extra hours so he could have the money to finish this probation. So we'd ask you to continue him, and now that he has the money to do what he needs to do.
And state recommendation?
Your Honor, the state agrees with probation's recommendation in this case.
And Ms. Gross, would you please advise the court and the parties of the status of a defendant being ordered to go or volunteering to go to SATF, what the time delay element is at this time?
Judge, it is quite extensive at this time, being that the state facilities are shut down. The felony cases are unfortunately taking priority over the misdemeanor cases. Most recently, we had someone in custody in the Bexar County Jail, just a little bit under 3 months awaiting transfer.
I do agree with her on the 3 months, Your Honor.
All right. Well, that basically shows that SATF is not really an option, doesn't it?
No, not really, Your Honor. I would ask to put him back on probation, 0 tolerance. I mean, this is his first MTR, and you always have the option to then revoke him and put him in jail.
And Judge, following up on the UA situation,
yeah,
I am actually in the program that lists every UA ordered. He did his test on the 27th. He did not take one on November the 2nd. And I show that he was not taken into custody until November 5th. So he did skip yet another test.
And the only program that Mr. Perez has completed that we're aware of is the DOEP course. Is that correct?
That is correct, Your Honor.
Ms. Middleton, do you have any evidence that Mr. Perez completed any other courses other than DOEP?
No, Your Honor. He's doing them one at a time because that's how his money was allowing him to do it. And he was in the middle of CAT-SNP. He said he had 4 classes to go.
So are you telling me he's using all his money to buy marijuana and he can't afford to go to the classes?
I would never tell you that, Your Honor.
I see. All right. Mr. Perez, the clause 643-213. Court accepts your plea of truth and explanation. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail, SSA. What's the original fine, Susan?
$500, Your Honor.
$500 fine plus court cost, credit for time served, time and money to run concurrent, recalling all pretrial services, bond conditions. Anything further from the state of the defense on Mr. Perez?
I have something quick. Mr. Perez, I will do a Smart Start mobile removal order. The
Yes,
judge
ma'am.
will sign it. It'll probably get sent over either Friday or Monday because of the holiday.
Yes, ma'am.
And then you can ask one of your family members to go and turn it in for you, okay?
Yes. Will I be able to talk to my lawyer as of right now after this?
Your lawyer can ask to be put into a breakout room after the judge has completed his speech.
Pat, are you still with us?
Yes, Your Honor, I'm still here.
Can you send Ms. Middleton and Mr. Perez to a breakout room, please?
Yes. Room 3, Sunny.
Thank you.
Okay, Mr. Acevedo, are you ready to proceed on Ms. Howell?
Yes, we are, Your Honor.
This is cause number 650-463, State of Texas versus Desiree Howell. This is a first amended motion to revoke community supervision. Ms. Howell and Mr. Acevedo, the first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both of your signatures on. In fact, Ms. Howell, is this your signature on this document, ma'am?
Yes, Judge.
And Mr. Acevedo, as attorney for Ms. Howell, is also your signature on this document.
Yes, it is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which should be marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. And once again, Pat, that needs to be marked because on my copy, it's not marked. And Hal, is this your signature on this document also, sir?
Yes, Judge.
And I'm sorry, Ms. Hal. And Mr. Acevedo, is this your signature on this document also?
Yes, it is, Your Honor.
Okay, Mr. Acevedo, my understanding is that this is going to be an uncontested motion to revoke community supervision. Is that correct?
Yes, it is, Your Honor.
All right, Ms. Howell, in cause 650463 on the first amended motion to revoke community supervision, how do you plead, ma'am?
True.
And Ms. Gross, would you please advise the court and the parties of the status of Ms. Howell's probation?
Yes, Your Honor. Ms. Howell has been reporting as directed. We last saw her on October 14th, 2021. She has paid $397 towards her fees, has a balance of $909 and is current at this time. We have no record of any of her 48 hours community service having been completed, and she has provided proof of completion of DWI education and victim impact panel, and we have no proof of completion of the CATSNP program. She is currently testing on Smart Start Mobile at 4 times per day. She has had 7 skip tests. She's had 1 high BRAC, which occurred on October 31st, 2021 at 0.139. And that was at 6:39 a.m. And it did not clear until after 12 p.m. And there was no retest provided after the high BRAC. She does have 1 diluted drug test and 1 negative drug test. She has no criminal history. This is her first violation report, first MTR, and her officer is recommending that she be placed on weekly drug testing and that she shows substantial compliance within 30 days.
And Mr. Acevedo, somewhere in my notes, it shows that Ms. Howell is currently active in the Community Alliance for Traffic Safety New Intervention Program, i.e. she is actively going to classes for CATSNP at this time. Is that correct?
Your Honor, she has registered, but she registered right around the same time that she was taken into custody. She was taken into custody while she reported. She continued to report even though she knew that a warrant was going to be issued. And of course, she was apprehended there at the probation department. She availed herself to the probation department. She has not started the class, but she is registered.
I got you. And my information shows she has 6 days in jail. Does she have more than that at this time?
Your Honor, she has 6 days in jail. She had, when the family originally contacted me, their intentions were to try to get her out on bond. Ms. Howell herself called her family and said, no, I need to accept what I've done, and I will sit here until the judge is ready to see me. So she kind of self-imposed some punishment on herself. You know, when she turned herself in, she knew what was going to happen.
Okay. And state recommendation, please.
Yes, Your Honor. The state's recommendation is to continue 6 blows per day with weekly UAs and substantial compliance within 10 days.
Your Honor, if I may, on behalf of Ms. Howell.
Go ahead.
Your Honor, we would ask the court to follow the recommendation. I conferred with the state earlier today, and we would ask the court to follow the recommendation. She has completed the victim impact panel, the TW education class. She started doing her community service hours in late October, and she is current on her fees. She's gainfully employed, and she puts in at least 40 hours a week with her employment. And she is determined after this stint in jail to satisfy her conditions of probation and not end up back in jail on this matter.
Okay, she's currently on Smart Start Mobile at 4 blows a day. Is that correct?
That is correct, Your Honor.
Ms. Howell, on cause 650-463, the court accepts your plea of truth with an explanation. I deny the state's motion to revoke your community supervision. Order you continued on community supervision with all prior requirements with a sanction of 10 days in the Bexar County Jail, credit for time served, judgment satisfied, altering and amending conditions, modifying your Smart Start mobile device from 4 blows a day to 6 blows a day within 24 hours, and adding weekly UAs and adding substantial compliance within 30 days today, meaning you need to be registered for, which you may have already done all this, registered for any programs you're not currently registered for, and they'll start you as soon as they possibly can. And I think you're already doing that because you're already signed up for catching up. They just haven't started you yet. When I'm cranking you up to 6 blows a day, if you show me a 30-day period of time with no skip tests and no high brax for alcohol, I'll crank you back down to 4 blows a day. And Paul, if she does that, I won't know she's done that. She's got to tell you, you got to tell me, and I'll call probation to confirm it. And then I'll order her back down to 4. Same thing with the weekly UA. Show me 4 clean weekly UAs in a row. I'll put her back on monthly UA. I will not know she's done it. She needs to tell you, you need to tell me. I'll call and confirm it with probation, and I'll order her back to monthly UA.
Understood.
All right. Anything further from the state of the defense on Ms. Howell?
Nothing further, Your Honor.
Good luck, Ms. Howell. Thank you, Mr. Acevedo.
Thank you, Judge.
Thank you, Judge.
You bet.
Ms. Howell, I'll be emailing you some conditions, so they'll be in your email box when you get out of jail. You need to sign those and return those back to me. And your officer will be increasing your blows sometime today. I will have her email those to you as far as your new times go, so that they will be available to you as soon as you are out of the Bexar County Jail.
Do I have the same probation officer?
Your officer is Miss Allen Juarez.
Okay, no, so I have a new one. I haven't met her yet. I'm sorry, I apologize.
Yeah, no, that's not a problem. Yes, so you'll be reporting to Miss Juarez. So look for an email from her with your new testing times.
Thank you, ma'am.
All right, good luck to you.
Good luck, ma'am.
Thank you.
Okay, are we ready on Mr. Hernandez, please?
Megan?
What's going on with Mr. Hernandez, please?
Your Honor, is my understanding that this is a case defendant has a felony and the plea, I believe, was done by the felony ADAs, and Megan wanted to, I don't know whether she knows or not, so let Megan tell you.
All right.
Yes, Judge, there were just no notes in our system, so I just need to speak with Mr. Meadows briefly, so he can get me that offer, and then we should be good to go.
Sure, absolutely.
All right. Breakout room 1 so that y'all can talk real quick. And all right.